Welcome to the Making Kids Count podcast, brought to you by Kentucky Youth Advocates, where we sit down with policymakers, community leaders, and youth to discuss ideas to make Kentucky the best place to be young.
Welcome to the Making Kids Count podcast. I'm Shannon Moody with Kentucky Youth Advocates, our Chief Policy and Strategy Officer here. We are now recording on day 14 of the 60-day session for our General Assembly, which means that there's several more weeks of bill filings and ample time for priority bills to get moving this legislative session. Just a reminder for listeners to check in on KYA's bill tracker to stay up to date on blueprint priority bills and other bills that are good for kids and families. And today I'm joined by two leaders in the child welfare arena to discuss one of the blueprint for Kentucky's children priorities, which is around family legal representation. We are joined today by State Representative Stephanie Dietz. She represents the 65th House District, which is part of the Kenton County in Northern Kentucky, and she's chair of the Budget Review Subcommittee on Justice, Public Safety, and Judiciary, and serves as a member of several key committees, such as Families and Children, Judiciary, and Appropriations and Revenue. We are also joined today by Judge Marcus Vanover, who serves as the Chief Judge of Family Court in Division III of Kentucky's 28th Judicial Circuit, comprising of Lincoln, Pulaski, and Rockcastle counties. We are really grateful to have these two joining us today. They have a wealth of knowledge, and I'm looking forward to really digging in to the topic at hand. So just for some background, in December, Kentucky Youth Advocates released an issue brief where we really dug into the importance of family legal representation and high quality legal representation for families who are engaging in the child welfare system. In that report, we offer recommendations to strengthen the process here in Kentucky. And as we dug into quality legal representation, we've talked to attorneys, former foster youth, birth parents, judges, child welfare system agents and frontline workers, as well as legislators and other decision makers in the field. So I'm looking forward to having a deeper conversation around high quality legal representation and also just what child welfare legal proceedings and the child welfare system looks like on the court side with our two guests today. So I'll start with Judge Vanover. Would you just get us kicked off with a bit of background before we dive into the focus of the conversation around the ways that you serve kids and families in your role within the courts?
Okay. So I guess the main way that I'll say that I served kids and families is as judge, we preside over our child welfare cases, dependency, neglect, and abuse. That overlaps somewhat in with some of our kids that come before the court also on status offenses, beyond control and habitual truancy, usually. Often we're looking at what issues are arising that's led to those problems, whether it be services needed for the child or services needed for the entire family. So we're looking at all of those things. We also preside over domestic violence cases. Domestic violence is one of the key factors in child welfare and endangerment, and one of the unfortunate statistics. It leads to a high incidence of child fatalities and near fatalities is a key contributing factor. So we preside over domestic violence cases, and we're trying to identify those risks and issues for the families and protect the children as well. I guess on a more tailored note for my work, I've also served on the Kentucky Judicial Commission for Mental Health, where I oversee the Dependency, Neglect, and Abuse Work Group. I participate with the Judicial Engagement Group, which is, I think, oversaw by Kentucky Youth Advocates, and brings together community agencies on a statewide level, notably representatives from the cabinet and representatives from the judiciary, to make sure that we're working together and identifying issues that we're seeing to try to make sure that we're all aware of any hiccups in the system and trying to address those as we can, and making sure that we're staying on top of whatever initiatives and policy changes that are working through either the courts or through the cabinet, and addressing concerns with other partners, and agent and initiatives that they have. And then finally, I have also served on the Family Court Rules Committee for several years, and was involved with the plan in 2019, I believe, with the subgroup that worked on coming up with the guardians ad litem and court-appointed counsel rules and guidelines that were adopted in the Family Court Rules in 2020.
So it sounds like you get to see everything from that case level, individual and family issues when you're seeing them at some of the worst times that they're probably having in their life, up to really high level policy decision making to influence the system overall. You get kind of a taste of everything.
I believe that's a good summary. That's a
Yeah.
good summary.
So, Representative Dietz, can you talk to listeners briefly about the ways that you serve kids and families in the child welfare system through your work as a legislator, or outside of that too as an attorney?
Yeah. So going into my fourth year, my second term in the state house, and I've said that I've kind of stayed in my lane with bills that I've run. So I know that the past 2 years I've done some work with domestic violence, guardian ad litems, making sure that we have those in place for EPO, for DVO hearings, making sure that we have an avenue for guardian ad litems to get paid in some of the circuit court cases. So have kind of stayed in that area. I would say since I got to the state house, an idea in the back of my head and something I've been passionate about is to revamp that guardian ad litem system. Knew it's a big bite. It's a big bite. And I don't know that I knew enough my first year, which was a 60-day session to work on it. Didn't know that I had enough in my third, with the 30-day session, my second year. And then last year we started talking about it. So I have a bill that I've been working on. I think you've seen an initial draft. It's gone through a couple of different drafts. I'm hoping that by the end of this week or next week that I'm in a place that I can file that bill. It's really, I was a guardian ad litem at the very beginning of my practice, and I think DNA court looked a lot different than it does now. I remember I would get a call from the judge saying, "Can you represent this child or mom or dad?" So we didn't have panels or anything like that. I've seen a big change in that in the three counties in northern Kentucky, and Boone, Kenton, and Campbell, that I typically practice in as a family law attorney. I know, we've got one court that has DNA cases 3 days a week, and we have another judge in Kenton County that can do it in 1 day a week. So really, the report that I think Judge Vanover talked about, and then adopting some of those, the rules in the family court rules that came out of, I think, a report that was done like in 19 or 20. We've looked at those and just want to make sure that we have quality representation for kids and for parents in this place, and to see maybe and I've talked to you about this. I feel that, the payment issue for guardian ad litems is one that's a little harder for me to wrap my arms around. And I just don't want to throw money at a problem, but how do we make sure that those guardian ad litems that are taking on those really hard cases that end up in a trial are being paid a fair amount? So that's something I want to look at. And in this bill that I'm drafting now, I think we've asked that they do a study on those payments without me trying to fix something. I'm kind of looking at this as, you've heard the phrase, how do you eat an elephant one bite at a time? So I'm trying to do it one bite at a time, and it's not to ignore all the issues. It's what can I get done this session that's going to start to bring about some change. So in that space, I've tried to be, a lot of times people ask me to look at bills before they file them or after they filed them. So I'm always keeping my eyes open. I send them, I know, to my family court judges. I send them to other people and say, can you give me your thoughts on this, so that I can try to preempt maybe something that would have a longer term, unintended consequence. And then just in my practice, I still take private cases. It's a juggle, especially during the 60-day session to maintain your practice. When, typically I work till about noon on Mondays before I head to Frankfurt, and then um, have set myself for some late hearings on Fridays, and then work on Saturdays with the attorneys that want to work on Saturdays. So my focus has always been, with family court, looking for ways that we can help families. One, I want to keep people out of court for as long as they can. That resulted in that collaborative family law bill a couple of sessions ago. But for when they are in court, just making sure they've got quality representation.
So let's dig in a little bit to the importance of that quality legal representation when we're thinking about kids and their parents in the child welfare system. We know that quality legal representation, based on what research says, can help to determine the length of a case, how long a case goes on for. It can help determine reunification services and supports, or timelines to permanency, visitations. There are a lot of things that high quality legal representation can influence for our kids and families. And it's important to take a look at. And Representative Dietz, like you said, it's a complex system, right? There's a lot of factors there, and a lot of things that determine how we get to high quality legal representation. Are the attorneys being supported and held accountable in the ways that they need, whether that's through compensation, whether that's through structures for training and things of that nature. So there's a lot of factors in, and I'm really grateful to hear about the steps that you have taken and others have taken, and really trying to tackle this issue and look at it kind of incrementally, because we can see some long-term change happen as a result of those small bites. So, Judge Vanover, can you talk a little bit about the roles that courts play in providing that legal representation to children and sometimes their parents in those dependency, neglect, and abuse cases?
So the first main part of what we do is obviously we are appointing counsel in the cases for all children, and usually in our child welfare cases, most of the time for parents. Most of the families will qualify for appointed counsel. It varies from jurisdiction to jurisdiction, but at the initial appearance, um, you know. At least by the initial appearance in court, a guardian ad litem is appointed for the child. Some places will appoint them as soon as the petition's filed. Some will appoint them right before the hearing. Some of them will appoint them at the hearing. And that varies from place to place. But by the time the hearing starts, there is a guardian ad litem, or at the initial part of the hearing, there's a guardian ad litem in place for the child. If the parents appear the first time, the court is issuing a summons for the parents as soon as the petition's filed. On that, it provides notification that they are entitled to an attorney. At the first appearance that the parents make before the court, they're also being advised that the parents are entitled to an attorney, and advised that they need to fill out an affidavit of indigency to see if they qualify for appointed counsel. If that can't be done immediately, sometimes the attorneys are conditionally appointed at the beginning for the parents, contingent upon the affidavit being filed quickly, so that they have. There's case law that says that the parents are entitled to legal counsel at all critical stages. Certainly, the initial appearance and removal phase is a critical stage. So, oftentimes, even if they aren't able to complete the affidavit before that, sometimes counsel will be appointed conditioned upon that being filed, at least for that initial appearance, so that we cover the critical stage appointment. The appointments are made from a list of attorneys that most of the judges maintain. This list is made up of attorneys that have requested to be appointed. In some jurisdictions where we don't have as many practitioners, sometimes the judges recruit people to come on their list. I've had to ask in some of my smaller counties, attorneys from other places to come in and take appointments. So we've had to recruit attorneys to come in and take those appointments. And I hear a common theme of that across the state, where judges are asking people to come on. And so we also oversee that those attorneys are qualified. We make sure that they have had the appropriate training to initially be placed upon the list. With the advent of the rule change in 2020, one of the requirements that we made is that the attorneys must maintain regular ongoing education. So we also every 2 years, I believe it is, the attorneys are required to send an updated letter to make sure that and show what initial continuing legal education that they've had to make sure that they're maintaining, the adequate standards of law. We broadened the training that the practitioners get to not only include legal standards, but also include things such as mental health and child development and other mental health and behavioral health aspects, because that's an important part of what we do with our dependency, neglect, and abuse cases, is we see a lot of families where mental health or substance use or misuse is an issue. So we want to make sure that our attorneys are getting some training in that and how to deal with that. And those were adopted into the rules in 2020. We're keeping an eye on making sure the attorneys are prepared when they're in court and in cases, directing, if necessary, that, especially regarding ad litem, we want to make sure that they're meeting with the children, or at least the custodians regularly. If the child's too young to communicate, we want to make sure that they're keeping up. If there's a significant change that needs to occur, we want to make sure that we get the child's perspective from that, and we will ask for updated information from the guardian ad litem. Another thing that we've done, following the adoption of the rules in 2020, there was a push amongst a group of attorneys, judges, Chief Justice Lambert, and the Chief Judge of the Court of Appeals, Larry Thompson, were all involved and oversaw. We revised our guardians ad litem training to coincide with what we adopted in the rules. There was a big push to revamp our curriculum for the trainings, and make sure that we were staying current, updating it with the law, and including some of those aspects from behavioral and mental health issues that went along. So we were to make sure that, if we were requiring this training for these attorneys, that we were giving them an option to receive quality training. So we did that revision. Fortunately, the rules went into effect in February of 2020, and COVID came in and put a big roadblock in front of a lot of things in March of 2020. So, we were trying to implement a lot of these changes while we were trying to figure out how to conduct court remotely. Which, we weren't seeing our participants, we weren't seeing our practitioners in person, which made that a bit of a challenge. But once everything reopened following COVID, we kind of tried to maintain, that we're getting our attorneys trained, that we're making sure they're doing what they're supposed to be doing. But with the advent of the Kentucky Judicial Commission on Mental Health and our Dependency, Neglect, and Abuse work group, we've continued to oversee the training of the attorneys. We do trainings that are offered twice a year in the spring and in the fall, and each one of those is done in 3 places. We try to include one place that's centrally located, one place in the western part of the state, one place in the eastern part of the state. We revamp the curriculum each time we do those trainings, and we review evaluations of the training to make sure that we're responding to what the practitioners are needing as part of their training, and taking into account what they're suggesting that we do for those trainings. So that's, I think, a summary of not only what we do in court, but what we're doing on a court-wide level to try to make sure we're maintaining quality representation.
Yeah, and what you said, as far as like a lot of these cases are complex. There are a lot of things that our attorneys who serve our children or parents need to know and be aware of, whether it's just the dynamics of relationships or child development. Judge Vanover, what do you see as some of the reasons why some jurisdictions are struggling with adequate representation for families. Why are judges having to go recruit, do you think?
And this isn't just unique to dependency, neglect, and abuse cases. The Kentucky Bar Association, for several years, has had initiatives, kind of like a rural attorney or rural legal needs drives, because we're seeing a large decline in rural attorneys in general. I will point out that of the counties that I do, the 3 counties I do, I don't think I have a practitioner on my list that's been practicing fewer than 10 years. We're just not getting an influx of attorneys that come into the rural area. I do take that back. I do have one now that started 2 weeks ago. But we're just not seeing an influx of attorneys coming into the rural areas. And if they do, they're not really interested in taking these cases. And frankly, I think partially because the pay is so low. And some of the counties don't have enough volume of cases to overcompensate that. You know, it part of it stems from people are able to make more in the cities, and you've got the with the advent of tuition and costs of everything going up, and attorneys are coming out with large student loans. There's just not a practical solution for people to come practice in rural areas when they know they can make more and pay off those loans in the larger areas. And I think that's a big portion of it. There's also services and resources that are available in general. You just don't have as much available. For families or attorneys with families and children, you may be looking at, they think that I disagree with this, but they think they can get better education services for their children in the larger towns. But there's a whole litany of issues.
So not just, is there a challenge around the complexity of the cases? Maybe pay is influencing some of that, but also just you might not have as many attorneys who are wanting to work in the rural areas because there's not as many cases to take on, or it's not necessarily what they're looking for.
That's right. And I think pay obviously is a big portion of that. Um, but I don't think it's the sole issue.
Yeah.
You know,
Representative Dietz, I'm curious, just from a legislative perspective, you spoke to this a little bit earlier about what you're looking at, maybe some potential movement this session, or at least a bill that's being worked on for this session. Where do you see the challenges and opportunities surrounding quality legal representation in the Commonwealth?
Along the lines of what Judge Vanover was saying, it's, the complexity of our state, the rural and the urban. And so, and I'm familiar with what Judge Vanover, is talking about, these legal deserts. I think we've heard a lot of. So that's one of the issues. So sometimes in these counties, you may have the county attorney, you can have your Commonwealth attorney, and you have your judges, and maybe 1 or 2 attorneys that are practicing. So, and then we've got judges that are on circuits. I mean, I'm in Kenton County, so and represent. I have cities, so I don't even have a whole county. So we're pretty dense in our population, much like Louisville and Lexington. So, I think part of what one, it's always budget. It's budget year, so it's money. And with this bill, what I hope to do is to just shift where the money is coming from. We're also looking at some federal funds that we don't know that have been pulled down on, and in this bill, it's going to require the cabinet to pull down on those. And I've tried really hard to get that information from the cabinet. I've not been successful. I've got some people in leadership now that are trying to help me get that information, because it would really be helpful as we try to work on something that's good for all the kids and the parents in our Commonwealth. But so one struggle is always going to be money and that shift. I think two, it's a new idea. I think we have 8 lawyers that are in the majority in the House, and not all of them practice in the area of family law, or familiar with all the stuff we're talking about when you say DNA, and how that follows through with maybe a divorce case or a custody case, and the things that the judges are seeing when they pull a file. So I think part of it is education with my caucus, with the body as a whole. And even if I'm hopeful that if I can get parts of it moving, if not the whole bill, then I have to go to the Senate side, and then I'm going to have to start talking to, my senators, I think first, that are familiar with these issues. So it's education of the caucus. It's the diversity of our state going from rural to urban, and maybe even how each judge handles their courtroom. I know 2 years ago when I started talking about the idea of this. I got text messages, I got emails. Why are you trying to shut this down? I'm not trying to shut it down. We're trying to look at it in a different way so that we can make sure that we've got an organized something that's organized. When we look at the statute and we kind of did a breakdown of where guardian ad litems are throughout our statutes, they're all over. And every time somebody brings a bill, it's like, oh, and we'll just appoint counsel. Well, that does get expensive, and I do chair the budget for judiciary, so I have to be thoughtful on when I see that, where's the money going to continue to come from? And I think for fiscal year 25, it was $14.5 million that went for guardian ad litems and court-appointed counsel. And I think that's before we started appointing for EPO. So, that number will be different when we get to the next fiscal year. So, those are all the pieces that I struggle with is one, pulling it all in, and it is kind of a monster, and we're changing. Along with that, we've been working with DPA because it is budget year, and some changes with DPA and in what they will cover. And I'm hoping we get that bill filed because some of those things may affect the guardian ad litem bill. We're not necessarily affecting, children in DNA cases, but, when we appoint for adults. So I'm trying to make it a comprehensive overall bill. So maybe, as we've talked, maybe it's too much for one session, but definitely how interesting our state is with the rural and the urban always seems to be part of the dynamic when we're working on this type of a bill.
Well, and I appreciate your approach on this. I know that there's a lot of factors that come into play. One of the things that I did hear you say, and I will share this with our other advocates who are in this space, is educating our legislators on the issues at hand, why quality legal representation is important, why it could save money in the long run if we've got kids who are not lingering in care and families who have the services that they need. So there's a lot of opportunity, a lot of work ahead, I'm sure, and some challenges that will come along the way, but I'm just really appreciative, Representative Dietz, of the work that you have done in this space, and Judge Vanover, and the work that you've done on the just systems level, whether it's court rules or understanding how systems are talking to each other within the Judicial Commission on Mental Health. It's really inspiring to watch you two at work in your different respective roles in looking for ways to make kid outcomes when it comes to in the child welfare space especially, but really just generally better off for kids across the Commonwealth. So I appreciate your all service as a judge, as a representative. You could be doing other things with your time and with your talents, but we're grateful as a Commonwealth to have both of you serving in this space, and many other of your colleagues that work tirelessly in the child welfare side of things and the court side of things. So just thank you so much. Just as a reminder to listeners, there are opportunities again to access the bill tracker and visit kyouth.org to learn more about Blueprint priorities, find advocacy tips, talking to your legislators, and also find those issue briefs on family legal representation on our publications page of KYA's website. And just thank you so much for tuning in to Making Kids Count podcast, and we'll see you next time.
Thank you for listening to the Making Kids Count podcast. For more information and to listen to more episodes, visit kyouth.org/podcast. To support this podcast and our mission as the independent voice for Kentucky kids, please consider making a gift at kyouth.org/donate.